owner of Eagles Painting. First up, Lloyd Tate. Welcome to the show.
Good to be here, Chris.
Now, Mom always told me that I need to surround myself with an attorney, at least one, and one CPA. So why do people need a criminal defense attorney?
Usually, Chris, folks need a criminal defense attorney when they're, of course, maybe charged with a crime or think they're going to be charged with a crime. And they don't usually know their rights. When police start questioning someone, they're professionals. They know and usually work backwards from trial back to the scene. The person, when they're talking to the police, they're usually nervous. It's usually unpleasant. They're scared. They may be in trouble. And so when you hire a defense attorney, you're hiring someone that knows the defendant's or the person's rights. That's the most important. You have to have your rights protected,
Right.
And levels out the playing field.
Fantastic. Now, when's the best time that I'd hire that attorney?
And what I always tell my clients or potential clients is that you need to hire a defense attorney when you get that uneasy feeling in your stomach that, this may not turn out so well. So if the person starts feeling uneasy, I may have legal problems, they need to hire an attorney or at least consult with one.
So what should a driver expect if they happen to be at the scene, if they're pulled over by a police officer who suspects them of driving while impaired?
Okay, let's talk DUI, or driving while impaired.
Because that's big here.
Yes, definitely. First of all, at the scene, the officer can give them what is known as field sobriety test. And those field sobriety tests aid the officer in trying to tell whether the person's impaired or not. Okay?
Right.
And so you've seen it before on TV, the touch your nose, walk the line, all of those type of field sobriety tests that help aid the officer in the investigation. It's important to remember, though, that the portable breath test, you've probably seen the poster where the officer is holding a device machine up to a person's face, and that's for them to breathe in. Again, that's another aid to the officer to help him tell. It gives him a preliminary reading of the person's blood alcohol content. But that's not admissible in court or can't be used as evidence in court. So
Interesting.
That's what happens first. And then the officer begins his or her investigation. What have you had to drink? They're watching to see, are you impaired? Is there a slight sway, odor of alcohol on your breath? Things of that nature. But those are things that happen particularly at the scene for the officer to do his DUI investigation.
Fantastic. So let's say I'm on the scene and I'm there. What should I do if I'm being pulled over? What are my rights?
Well, you have a right not to do or take the field sobriety test. Okay. Now, the officer can make a decision also that maybe if the officer thinks that you're impaired, arrest you without doing the field sobriety test. But a person has a right not to take the field sobriety test. Touch your nose, walk the line. But when you sign for your driver's license, you sign saying that you will give a blood or breath test if required or asked for by the officer. And what's important about that, Chris, is that if a person does not take that blood or breath test, refuses to, you can lose your license for up to 12 months. All right. So it behooves a person to take the blood or breath test. And you also have a right to an administrative hearing if that's disputed, where you're saying, yes, I would take the test, and the officer said, no, you wouldn't. And so immediately you're looking at your license being suspended 15 days after the initial DUI arrest, but you can challenge the refusal, the officer saying that you wouldn't take the blood or breath test. It's also important to remember the police are going to get the blood or breath anyway, because if a person refuses, there are judges on duty for them to call, give the signs and symptoms, what we call signs and symptoms of impairment that they're seeing, and the judge most likely is going to give them authorization to take your blood or breath by force if they have to.
Oh, my gosh. Okay, so what will the court process be for that driver who's arrested while driving, they are impaired?
Well, usually what happens, and let's talk generally about the city courts, because it's a Class 1 misdemeanor.
Right.
So a person is usually going to go to Tempe City Court, Mesa Municipal Court. All of the city courts usually handle the bulk of DUIs. So the person can expect an initial arraignment. That's just letting them know what the charge is. And then they're going to end up going to a pretrial conference. Now, since DUI is punishable by jail time, at least either 1 day in jail, and there's other punishments for a DUI if it's more severe,
right,
they're either going to be appointed an attorney or if they hire an attorney, but they're going to have a right to an attorney. So then you're going to have a pretrial conference. The prosecutor is going to be offering a plea agreement and things of that nature. And that's where it gets really important in hiring a lawyer, because it does make a difference.
Absolutely.
It makes a total difference on if, let's say, for instance, the legal limit now is 0.08. It makes a difference if you're under 0.08.
Right.
It makes a difference if your blood alcohol content is high. How do we mitigate what has happened? And that's where your lawyer comes in to help with, look, how do we minimize this, or look at this DUI and make sure that it's been investigated properly. You may need to take the case to trial. You have a right to a 6-person jury. So a lawyer is very important in this process.
Now, I've heard rumors on the cost of a DUI for a client if they don't use an attorney. It's quite expensive if a person doesn't have the right guidance. Isn't that true, Lloyd?
Yes. There are certain costs that if you plead to a DUI, statewide in Arizona, they're mandatory minimum fees. I won't go through all of them because they're numerous,
right,
and it's expensive. But let's take, for instance, there's a prison contribution fund. That goes to the state general fund. There's a Department of Public Safety fund. A lot of these fines are built in to the mandatory minimum. But the judge also has discretion to give more fines and fees. From $2,500 is the maximum, but there also can be an 83% surcharge. It gets you up to somewhere around $4,300, a little over $4,300. The judge has the discretion on whether to charge you for the days that you spend in jail at a rate of $267 a day.
Jeez.
So there's a lot of discretion, and that's where your lawyer helps in trying to negotiate the best deal for you. And even, again, if it's a bad situation, to try to mitigate the situation.
So in this case, it's just great to have Lloyd Tate here, because you never know when you're going to need a criminal defense attorney. And you're not a criminal, but it's nice to know a good defense attorney that's got your back, because you might just get that one call and you might need to call Lloyd Tate.
Yes.
Really?
Experience matters. And we've been doing this for about 23 years, and it really does make a difference in a person's future and in their life.
So in the case for that driver who's arrested for driving while impaired, especially if he knows he's impaired, why should he even call an attorney?
Again, a little bit of what we talked about before. One, if it's a very horrendous or egregious situation, let's say an accident or things of that nature, the punishments can vary. And so what you want an experienced defense attorney to do is to try to help mitigate. And what I mean by that is, to the prosecutor and to the judge, there may be other mitigating factors that may not necessarily be a defense, may be, but also to help the judge understand, because the judge is the one ultimately that's going to punish. Help the judge understand what are the good things about this person that were going on in their life. Maybe they were going to school. Maybe they were having a bad situation. Things that the judge should know about to try to help mitigate that punishment.
Fantastic. Okay, so a person, or let's just say their son or their daughter, has been charged with a crime, and they receive a phone call from the police who say they just want to talk to that person, or maybe that son or that daughter, about a particular incident. Now, that person does not think that he, or again, the son or daughter, has done anything wrong. So is there any reason for that person not to talk to the police?
Yes, Chris. They're in our nature, I think, in most persons' nature. They want to tell their side of the story, or their son or daughter's side of the story. And so often police, and they're not bad folks, they're professionals trying to do their job. They'll say, well, look, tell us your side of the story. And that's most inviting for a person to sit down and start talking. But again, the police officer, the professional, is working backwards from trial backwards.
Right.
And the person doesn't know. So a lot of times, let's say a person might say their son or daughter is accused of aggravated assault, of maybe pulling out a knife or, unfortunately, maybe a gun on someone. Okay. But let's use the knife incident.
Okay.
They have the knife in their waistband. And the police officer asks, well, did you show the knife to the person? Yeah, I mean, I didn't pull it out, but I did show it to him. Doesn't matter. The person has just confessed to an aggravated assault where they can be imprisoned from 5 to 15 years.
Wow.
So it's very important to resist that temptation to sit down and talk to Andy
Stop
Griffith
talking.
and tell Andy Griffith, just tell Andy the story. It'll be okay, because it may not be okay.
Well, we're here with the ultimate Lloyd Tate, criminal defense attorney. What's the best way someone can get a hold of you, Lloyd?
Best way to get a hold of me, office phone 480-345-1400, or on my cell phone, after hours, 602-571-0699.
And would you repeat both of those one more time so they can write that down?
Yes, office phone 480-345-1400, or by cell phone 24 hours a day, 602-571-0699.
Well, you gave great advice. Loose lips, sink ships, don't talk. Talk to Lloyd instead.
Yes.
They're in good hands. Peace of mind with Lloyd, right? Okay, so a person's been arrested. They're now at the police station. They're being interviewed by the police, okay? When is the best time during that interview to ask for an attorney?
Well, Chris, our United States Supreme Court says there's some magic words, and they're really unequivocal or very clear. A person has to ask for an attorney. I want my lawyer. And you've got to use those words. Then the interrogation has to stop at that point. The police cannot ask any more questions. And it's important that you do that at the beginning. If a person uses words like asking the officer, do you think I need an attorney? The officer is well within their right to say, I don't know. Do you need an attorney? Those aren't the magic words. So it's important to get an attorney at the beginning. Again, to level the playing field for a person to know their rights before they're interrogated by the police.
Okay, so let's say they go back to the scene. Can they say that at the scene if they're pulled over? Can they use that I want my lawyer when they're at the scene?
Yes, they can, but there's some more technicalities that are involved there. The card that they read, Miranda rights,
Correct.
What you say can and will be used against you. That technically doesn't come into play till you're either in custody, and that may be at the scene, or the officer starts asking you questions. Then they must read that Miranda rights card. So, yes, you can invoke that at the scene so that the officers can't ask you questions. But definitely once you've been taken into custody, whether at the scene or at the police station.
Very good. So if someone in that situation, we'll go back to the person that's being interviewed by the police at the station, they do ask for an attorney. Okay, they say, I want my attorney. Won't the police think that he's being or she's being uncooperative and therefore conclude that they must have something to hide?
And I would tell a person, it really doesn't matter what the officer thinks.
Who cares what they think, right?
Again, it really doesn't matter. It's more important that the person gets an attorney so that that person can get wise counsel before they start talking to the police. And it really doesn't matter what the officer thinks because, again, our Supreme Court says within limits, officers can use deception and use, another person
trained.
saying, look, the other person's already told us the story, so you better tell us your side. And again, it's important that they know a person has someone there or has counseled with a lawyer to know their rights before they start talking to the police.
So in your line of criminal defense, talk about the lines or types of defense work you do. So we're talking DUI. What other examples for the audience that are listening that you represent? Aggravated assault?
We handle everything from murder cases all the way down to criminal traffic tickets. So we're handling aggravated assaults, as you mentioned. We're handling major felony drug cases in federal court. We handle all state court types of cases, whether they're drug cases or domestic violence. And we also practice in city court also. Okay. I handle matters that, again, range the gambit from DUI, but that are Class 1 misdemeanors. We handle gun cases, white collar embezzlement, a number of different types of cases.
Mail fraud,
wire fraud.
You name it, you got it.
Yes, ma'am.
Oh, Lloyd. Okay, so let's talk about the driver. I'm going to go back to DUI because it's such a big topic, and I've heard so many cases, so many nice people driving around impaired. So a driver suspected of driving while impaired, and they're pulled over by a police officer. And in this case, the driver's been smoking marijuana. They have a medical marijuana card, of course. Now, the driver shows it to the police officer. Does having that card protect that driver from getting a ticket or getting arrested?
No, it does not. And there's a big misconception.
That is so good to know.
That if you get a medical marijuana card, you become exempt from driving while impaired laws. It does not. Not to get real technical, but what the prosecutor's office is looking for, your blood's going to be tested. And it's going to have, marijuana can stay in your system for 30 days.
Yep.
The hallucinogenic component of marijuana, THC, can break down into tetrahydroxy, which is the hallucinogenic component of marijuana. If that is found in your body, in your system, you will be charged with DUI. Now, if it breaks down further into carboxy, that further component, then you probably won't be. In the Supreme Court, our state Supreme Court just came out with a case on that. But the misconception by folks is that they can smoke marijuana and drive. If you drink orange juice and it impairs your ability to drive, you can't drink orange juice and drive a car.
Right. Or grapefruit mixing with cytochrome P450 isoenzymes with prescription drugs.
Yes,
Most
ma'am.
people don't know that.
They
right?
don't.
Absolutely. Okay, very, very cool. Now let's go to felon. And by the way, I'm with Lloyd Tate. Lloyd, let's give them your phone number one more time. I think they need to have that.
Office phone, 480-345-1400. Cell phone, 602-571-0699.
Okay, felon is in possession of a firearm. We've seen it on the news. It always seems like every time I turn around, there's somebody possessing a firearm. What does that mean?
Well, a felon in possession of a firearm is a person that is what we call a prohibited possessor. If a person has a prior felony conviction and they have not had their right restored, their civil right restored to carry firearms, then again, they're a prohibited possessor. And the biggest misconception here, Chris, is that a person thinks, well, if I'm riding in a car, let's say as a passenger, and they know that the driver carries a gun and the gun is in the console, let's say, between them, the passenger, let's say convicted felon, thinks, well, it's not my gun. I know it's there, but it's not my gun. So I can't be charged with felon in possession. Wrong. They can. It's not an ownership statute. It is a possession statute. So if they can exercise what we call dominion and control, if they can reach and grab that gun and exercise control over the gun, then they can be found guilty of felon in possession. And usually we're looking at somewhere about 2.5 years in prison for that.
Holy moly. So if you're driving with somebody with a gun, you better take Uber.
Yes.
That might be a wise idea. Okay.
Yes.
So that's interesting. Okay. So you advertise a lot, and your advertisement says you'll give a second opinion. What is that?
Second opinion is something that you conceptualized a couple of years ago, but we've been thinking about it. A lot of times a person can't afford to hire a private lawyer.
Right.
But they're in a situation, let's say, that they have a police report, they've been charged, and before they take a plea agreement or accept a plea agreement, certainly when they're getting ready to go to prison or there's some severe punishment, that they want to get a second opinion, just like a person would if they found out from a doctor that they had a very serious illness,
right,
and they want to get a second opinion. We provide the service of reading a police report and also going through a plea agreement, and we will go either counsel with the person at our office in a consultation or even go to the jail and meet with the person to, one, make sure that they understand, but give them a second opinion before they press forward, either with a trial or accepting a plea agreement.
Fantastic. So, Lloyd, you offer the second opinion. That's awesome. Let's give them your phone number one more time, because I think you never know who's listening. They might need a second opinion.
Again, office 480-345-1400 and cell phone 602-571-0699.
So this is one of my favorite questions. Why is Lloyd Tate different from the other criminal defense attorneys out there?
Well, I think that what I bring is a certain passion to criminal defense work. We've been practicing for 23 years, so we've seen a whole lot of situations. I have over 70 jury trials, over 100, 120 some bench trials or trials to the court. And so I think what I bring is to show folks, one, I care about their situation. I really do understand how people make mistakes and get themselves in bad situations. But we also have the necessary knowledge and caring and passion to help someone in a time of need.
Now, do you have a good success story to share? Take one of your recent cases that you've had that, I know it's confidentiality, so we won't name names, but talk about some of your success stories, Lloyd.
Well, and again, when we are looking at success, we have to measure it as to the seriousness of a case. If we can get someone that, years ago we had a person that was looking with the state filing a notice of death penalty, and we got them to denotice the case.
That's great.
That was a win.
Right.
Sometimes it is helping out a young person, let's say, that gets a hold of a credit card, identity theft.
Right.
And if you can get that young person, they are facing punishment, but maybe they're not getting a felony at 19 or 20 years old. We've had a couple of cases like that. That's a win because that person's future is not jeopardized. Sometimes it's mitigating a very bad situation. And we've had several of those. So we're proud of the work we do. And it's just a passion to try to help folks and do a good job. And I enjoy being in court. I enjoy being a trial lawyer.
Fantastic. Now, where are you located? Where's your offices located?
1921 South Alma School Road, Suite 304. That's Mesa, Arizona, 85210.
Fantastic.
So that's the 60 and Alma schools.
60 and Alma School. I'm here with Lloyd Tate. Lloyd, you've been great. You've shared great things with the audience. One last time, give them your phone number for the office and your cell phone. Office phone,
480-345-1400. Cell phone, 602-571-0699, 24 hours a day.